A durable power of attorney is a power of attorney that continues even after the person that creates it loses capacity. It's an odd distinction because most of us know that that's exactly when we want it to work. For a power of attorney to be durable, it has to include a sentence that indicates the power of attorney continues notwithstanding the later incapacity of the person that created it. And that's what makes it a durable power of attorney. A non-durable power of attorney would be used in a limited situation. For example, if I was going to be out of the country or out of cell range and I needed a real estate transaction to close, I could nominate an agent to handle the real estate transaction, and that power of attorney would not need to be durable. A medical power of attorney is frequently based on statute. It allows you to appoint an agent to make medical decisions, usually only upon your incapacity. An agent under medical power of attorney is typically granted a broad authority to act as though they were you. However, there are a lot of limitations you could add if you were concerned about whether your agent could put you in a nursing home or whether you wanted to be an organ donor or not. Things like that can be addressed specifically. Financial powers of attorney can be limited to specific powers. For example, if you wanted your agent to have authority to amend your trust, you would have to include that provision in the financial power of attorney. A provision that we sometimes include for clients that have estate tax problems is the authority to make gifts. But if we have a client that does not have estate tax problems, then we don't include the authority to make gifts. And that's just a couple of examples of specific provisions that can be included. Generally, within an estate plan, we include a broad-based power of attorney, but it still would not include the power to make gifts. A springing power of attorney is a power of attorney that's only effective when the person that creates the power of attorney loses the ability to think clearly. So it springs into power, the agent springs into power when the principal loses capacity. A power of attorney is part of any good foundational estate planning package. It acts as a backup or a supporting document to the revocable trust and the other medical related documents to make sure that anything that we can reasonably believe would come up in your life can be covered without court proceeding. In Utah, we have a document called an advance directive, which covers medical power of attorney items, but it also covers what's commonly referred to as a living will. And a living will is a place where you can express your desire with regard to life-sustaining treatment. If you have any questions about powers of attorney or the type you may need, contact us at ProvenLaw, and we're happy to help you.